Welcome to Own Your Zone podcast, where we feature venture capitalists, innovators, angels, and other investors who create positive impact globally. Now, let's get started with the show.
Hi, I'm JiNan Glasgow George, a patent attorney and founder of NeoIP. We are a law firm that helps clients maximize their return on investment from their patent assets. I'm also host of this show where we feature venture capitalists, innovation-focused private equity companies, and other early-stage investors. Today, I have John Corcoran here of Rise 25. He's done thousands of interviews with successful entrepreneurs, investors, and CEOs. Today, we've flipped the script and he'll be interviewing me.
All right, Jan, thanks for having me here. I love that focus on maximizing the return on investment, which is so important. And in this episode, we're going to be talking about software patents. When should you file a patent for your software? When shouldn't you? Some of the debates over whether that is a good thing to do or not. And so we're going to dive into that topic. And of course, this episode is brought to you by NeoIP, which helps companies increase their valuation and protect their business through strategic business planning and intellectual property protection. At NeoIP, they provide corporate and legal services to help companies manage risk, develop portfolios, and monetize their IP assets. NeoIP believes intellectual property is a valuable business asset with exceptional potential. NeoIP is here to protect that. Learn more about NeoIP at www.neoipassets.com. And if you'd like to talk more about your business needs, you can email them at admin@neoipassets.com. All right, JiNan, let's dive into this topic. So there's a big debate in the community, in the software community, about whether software patents are really a good idea or not, whether you should file or not. So let's just start right there. What are some of the people saying, those who are in favor of patenting for software and those who are opposed to it?
Sure, absolutely. Thanks, John. Yeah, there is kind of a big range on the spectrum for software patents that some companies say, yes, patent aggressively. I mean, you can look at Google, Apple, et cetera, and see that they are filing across all of their areas and applications. And then very often we see a lot of early stage companies and growth companies say, no, absolutely not. The patents are nothing. You just need first mover advantage for software. Others will cite open source as a reason not to patent. The patents and copyrights are outdated. And they couldn't be more wrong. In fact, there's a lot of room for patenting in open source. Just consider the likes of Red Hat, right? WordPress, et cetera. Open source code is actually used in most company software today. There are a lot of super proprietary closed programs, but most companies, in fact, do engage in some open source code. It's the applications for the code that can be patented themselves. And then also to think about the copyrights. Open source itself requires pretty rigorous IP protection in order to have all those who agree and coordinate with open source to comply with the terms. Here's another example that you might not think about in software. Cryptocurrency, right, and blockchain. These are all software. It's not hardware specific necessarily. When we look at data, which is what really tells us behind the scenes what's happening, we noted that Bank of America was patenting in cryptocurrency early and often, and in fact was leading for some time, even though publicly many of their executives were suggesting that crypto might be fraud. So it's really helpful to look at data and see what's going on behind the scenes before you jump to conclusions.
Yeah, especially with competitors, I imagine, or the other players in your space, they might be saying one thing, and it turns out that they're just behaving very differently behind the scenes. They're protecting, their future potential that against something like that. So that's a great point about open source. Even if companies that are pursuing an open source strategy, they may still be filing patents, but they're enabling others to use it.
That's right. That's right. And I think it's helpful to watch what the companies do rather than just listen to what they say, right? So many look to the major players like Google. Let's look at some of their merger and acquisition activity, motivated by patent position. Here's an example, Fitbit. They were number one in IP for wearable technologies and software that relates to them, particularly in applications as hot as consumer sleep, where there's been a lot of market activity and a lot of investments in IP. Both Google and Apple were active in the market, but were late to patenting. And so remember, when we think about patents, it's a race to file. So if you didn't build it yourself, you have to buy. And a lot of the larger players come into the market by acquiring patents because they are valuable.
And so that's what Google eventually had to do. They had to acquire Fitbit because they had not filed patents in this area. But what was really interesting is you saw this coming.
That's right. So with our patent forecast software, we watch every sector. And when we were observing this activity, we thought, this is coming. We could see it more than 9 months ahead of the announcement that either Google or Apple would buy them. We kind of had an internal bet inside our firm about that. But we see that this is a trend. Consider Google getting into mobile handsets, right? They came much later than Apple, Samsung, Nokia, and others. And so what did they need to do? Again, they became active with the Google smartphones, right? They had to buy another large portfolio, perhaps even some small ones as well, because they didn't have the exclusive rights themselves, but all the competitors did. So the acquisition of Motorola Mobility for billions of dollars was substantially motivated by the IP, by the patent assets, because after the acquisition, then the operating company was spun out.
And one of the considerations here is also just protection against some kind of litigation, right? That's part of the reason that they're doing this. So talk a little bit about that piece.
Sure. So think about it. I'm going to go back to our continuum discussion at the beginning. The people who say, no, it's all first mover advantage. Well, if you're a smaller company, even a mid-sized company, and you don't have the IP to keep others out, your first mover advantage is 6 months or less, because your competitors can spin that up, especially for software, right?
Yeah, even faster to spin up compared to hardware.
Exactly. And so without that barrier to entry into the market, there's no patent protection. What do you have? You have nothing. So if your competitors come into the space and they have patents and you don't, and there's an assertion of infringement against you, what do you have to settle with against your competitor? You only have your cash. The number one way to resolve a patent dispute is through cross-licensing, right?
Ah, fascinating. So explain what this is.
So cross-licensing is where a first company has patents that are asserted against a second. The second company also have patents, and they may read against each other because patent claims decide where the exclusivity is, right? So when we think about cross-licensing, the resolution is that each one agrees that the other can be licensed into their exclusive territory. So it's in effect kind of this mutual agreement that our keep off the grass applies to everyone else except each other.
Yeah, right? And so it could save you a lot of money.
Yeah. And so let's think about a large company example there, Tesla. Right? They have a cross-licensing approach to their EV business, which is hardware and software, but a lot of software. So when we look at Tesla in the mainstream media, has been reported that they are open source patents. They're not. Right. They're actually cross-licensing, which has been done by Intel and others for decades. When we think about Tesla's need to do that and what motivates them, they don't want the distraction of litigation. So cross-licensing early means they don't have to worry about that. They can focus on being number one, right, in manufacturing, in other areas, and let others share some of their EV software and other types of patents.
Yeah, fascinating. And there was also Tesla had a collaboration or a partnership or a deal with Mobileye, which was one of the early companies in data analytics and sensor data related to autonomous vehicles. Talk a little bit about that situation.
Right. This is fascinating. Again, we know it from our patent forecast data that we could see for autonomous vehicles. Some of the largest sectors of patenting were software heavy. It was on the analytics of sensor data. And a lead in that area was Mobileye out of Israel. And the early relationship they had with Tesla fell apart, as many partnerships do. And so with the breakup, what's left is Tesla with a big gap in its IP portfolio where Mobileye was strong. And so the cross-licensing, again, by Tesla makes a lot of sense to let them position in the innovation side, continuing to focus on development, on manufacturing, on leading, and not worrying about litigation.
So ultimately, to get back to that, yes, is patenting a good idea for your software company, or no, it's not worth it? You should just focus on first mover advantage. Ultimately, it's about, is this right for this particular company, not a larger debate, philosophical debate.
Exactly. And this is what we see when we talk with venture capital firms, private equity firms, and other investors in companies that are software heavy or software purely, is that they still want to see exclusive rights that come from patenting. And so it is really about this company and its market. And is this a good barrier to entry? And are these assets going to be valuable and perhaps even attract the exit, right? So when we, again, use this patent forecast data, we can see that positioning an early stage company for exit happens from the beginning. And investors know this. So even for software, there is a question that you will always get in diligence. Where is your IP? Do you have that?
Right. This has been fascinating. Before we wrap up, any final thoughts on this particular topic, software patenting?
Yeah, absolutely. I mean, our advice is every company should look at it and be informed by data. What are your competitors doing? What are the largest players in your market, in your sector doing? Do you have a unique value proposition that is suitable for creating IP assets? If the answer is yes, then err on the smarter side. Obtain at least some small patent protection in connection with the rest of your IP, your software, your code, et cetera. You don't have to put the code in the application. You have to describe its functionality and its features. So a lot of people are concerned about disclosing code. You don't have to.
That's a great point. JiNan, where can people go to learn more about you, connect with you, and ask any follow-up questions?
Thank you. My law firm site for Neo IP is neoipassets.com, and we'd welcome any contact through the site. Thank you for having me on today.
Excellent. Thanks so much.
Thank you for listening to the Own Your Zone podcast. We'll see you again next time, and be sure to click subscribe to get future episodes.